This 911 Strong podcast is brought to you by our partners at the Police Credit Union of California.
As a financial institution founded by law enforcement for law enforcement and their families over 65 years ago, they have the experience and understanding to help you with all your financial needs,
including exclusive products designed specifically for law enforcement professionals. To become a member today, visit thepolicecu.org. That's the police, the letter C, and the letter U.org.
Or call 800-222-1391 and tell them you heard about them from the 911 Strong podcast. Hey friends, Aram Choe here with Kristen.
Hey.
Thank you. I missed that. Hey, we're here talking about some of the changes in laws that affect law enforcement officers, namely SB2. If you're not familiar with what SB2 is, well, it affects your job. So you're not going to want to miss this. We have attorney Kasey Castillo from the firm of Castillo and Harper joining us today. She's got a lot to say about how this new law and some of the new laws that are out there affect the way we do our work. Is it scary? I think so. I don't know. What do you think, Kristen?
Yeah, just a bit. I mean, there's a lot to unpack in this one bill, and I think I still have a lot of questions too. So if you guys really like this episode, let us know. We'll have her back on and we'll dive a little bit deeper in there because there's a lot of stuff going on in this bill.
Yeah, so stay tuned because Kasey's going to answer a lot of our questions. I'm sure questions that you have on the next episode of the 911 Strong podcast. It starts
right now.
Station to all units.
Prepare to copy.
You're listening to the 911 Strong podcast.
Don't act like I never told you.
With Aram and Kristen, bringing you stimulating discussion.
No, I like the sound of that.
An entertaining conversation.
And now, here's Kristen and Aram.
Hey friends, welcome back to the 911 Strong podcast. With me, as always, is my co-host, Kristen.
Hello.
You're really trying hard not to say, hey.
You
I make
gave
fun
me
of
so
her.
much crap for that.
No, it's your tagline. You got to use that. People love it. People write in about that stuff.
No, they do not. You're such a liar.
They think, man, Aram, you really took the thunder away from Kristen by doing that.
Yeah, you just ruined the whole show. Our ratings have plummeted.
Well, maybe our special guest can recover the show now. Our special guest is an LDF attorney, legal defense fund attorney, and POA representation attorney. And she's very familiar with police departments in Southern California, and she's on the pulse of what's going on in the state when it comes to legal and liability related issues. And as a police officer, and Kristen, as a wife of a police officer, I think it's very interesting that we have what's going on in the state right now. So before we get into that too much, I want to introduce our special guest, Kasey Castillo of Castillo and Harper. Welcome, Kasey.
Hi, thanks for having me.
Well, it's been a long time coming. We should have had you here a long time ago when, some of these Senate bills and stuff first came up. But I think the issue a lot of us have is we're just not familiar with legalese and some of the clout that is surrounding some of the language here. And it's not familiar. So when I talked to you about this, it was very gracious of you to agree and give us free legal advice. We better not be getting a bill after this, by the way.
Yeah, I won't mention it to my office manager. Don't worry.
Okay. But your firm is very well respected, Castillo and Harper. I actually listened to your partner. Excuse me. Sorry. I thought I had my phone on silent.
So rude. I'm so sorry.
Brandy Harper at the law enforcement social media conference in Palm Springs a few months ago. And the entire time she was talking, I was like, I hope she doesn't see my page. What not to do. Yeah. Don't do this. Don't do that. But
that would be a good other topic also, what you can and can't do on social media again.
Brandy is so funny when she talks. She's very entertaining. She'd be great to have on.
Yeah.
Maybe you can convince her to come on our show one day.
You can. She loves to teach, and you just have to, be ready to hit the buzzer on the swear words here and there. But she'll do it for sure.
All right. Well, since we have you at our disposal, I know our listeners probably have a lot of questions that surround, legal stuff with police officers. But specifically, I wanted to talk to you about SB2 because SB2 was something we talked about towards the end of last year. Senate Bill 2 talks about qualified immunity and police certification. Basically,
right.
For the first time in history, California cops or cops anywhere can be decertified. You want to go into a little bit about what that means for law enforcement officers?
Well, not only is it a logistical nightmare, but it's probably a living nightmare for some people who maybe thought that a case was dead and gone in terms of conduct, and this could have it rear its ugly head again. Additionally, I think that you will see departments taking a closer look at conduct and maybe being less willing to negotiate resolutions that are outside specific allegations. You know, in the past, we have been successful with kind of working around facts to come up with a good resolution for the officer to, you know, keep their job. Most of the time that just is regular settlement discussions, right? But I think that you're going to see where departments are really taking a hard line on certain conduct because of this new codified bill.
Yeah, you know, some of the language in there is really confusing. One of the big things I talked about on my social media page towards the end of last year when SB2 was being talked about was qualified immunity. I think a lot of people have a misconception of what qualified immunity is, including cops,
Right.
people on the inside. Do you want to discuss a little bit about the difference between, you know, total immunity, which I think a lot of people think qualified immunity is, and what it actually is?
So it's whether or not they have immunity from being held to answer essentially for certain conduct. So what the new bill does is it means specifically that police officers are not going to be immune for liability for instituting or prosecuting anything that lacks probable cause, injury to a prisoner, failure to take reasonable action if a prisoner requires medical care. Those things that typically would have been borne on the shoulders of the department or the city, they're not immune anymore, right? They do have immunity for liability from violations like related to failing to bring someone to arraignment in a specific time. But what it really does is open the individual officer up to being held to answer in a court of law. And that is civilly, right? Qualifying immunity is for civil prosecutions.
Mhm.
It amends the civil code to allow state immunity provisions to be modified now.
Right. So like in layman's terms, you know, if I were to have this discussion with another police officer, and the way I was explaining it was, like, if you did your job within the scope of the law, within policy and procedure, and someone is seeking damages against you,
Right.
you should be covered by the city to protect you. They should have an attorney represent you. The city should go to bat for you. But if you do something illegal or against policy, you're liable for it, which should always be the case anyway, right? If you're not following the rules, you're not playing nice, and you do something outside the scope or authority of your job, you should be held liable.
Yeah. I mean, it's a tough pill to swallow because a lot of the times, you know, no one is thinking specifically that this is something that they are, you know, no one's planning to have interactions with the public where they're not following the law, or, you know, they believe truthfully in their heart, okay, I do have probable cause for this. Or, you know, I thought I was taking the steps that I needed to provide medical care, but it's always the step further. And I see a lot of these questions now as I go through with officer involved shootings, and more I hear questions from the investigators asking about, okay, well, how soon did you call for medical aid, and what kind of life-saving measures did you take? Because they want to get on the record that you are reasonably acting and you're doing it in a timely fashion and what have you. So I see more and more of those questions coming out in these, you know, investigations to make sure that not only is the city covered, the officers covered as well.
You mentioned a key word there, reasonableness. You know, if in the past, being reasonable, doing something that a reasonable officer, a reasonable person would do would kind of protect you from those liabilities, right? If a jury says, hey, well, I would have done the same thing the officer did. You know, I get it. He didn't follow procedure precisely or the law precisely, but his mental state at the time prevented him from doing it for whatever reason. That's reasonable. You know, just like in shootings, you brought up OISs, you know, was it reasonable for an officer to use that deadly force? And a jury might say yes. But now we're getting to the point where that language is kind of skewed, and it's now more necessary than reasonable. and people are looking at the necessary standard. Just because it's reasonable under your policy and procedure doesn't mean it's necessary. That's something that we have to kind of be cognizant about now, isn't it?
You know, officer involved shootings is a whole nother podcast. Have me on for that, because I'm telling you, I have probably been to 10 since the first of the year.
Oh, wow.
And it's just because I think criminals are becoming emboldened because they're really not being held to answer for their crimes. You see officers that don't want to be accused of failing to act, which is a new area of liability, right? So they walk the line of, I don't want to be in trouble for failing to act. I'm doing what I think I need to do to go home to my family.
Right.
And then they're sitting around for 3 years waiting for a DA turn down letter. And in the interim, some of these agencies have people on administrative leave while they're waiting to get those resolutions. So yeah, I mean, I literally make sure every one of my clients is very familiar with the language of AB 392 before they walk in to give any statement, because I want that in their mindset, and that should be in their mindset, you know, obviously at work as well.
You're absolutely right. And we're going to hold you to it. We are going to do another episode now that you brought it up for OISs, because there are a lot of laws out there that officers should be aware that they don't think about until it happens to them.
Right.
And, so going back to SB2, what are some of the other things that we should be cognizant about as we move forward in 2022?
So SB2 really kind of modified the standard in 4 ways, right? We talked about the qualified immunity. Additionally, it's modified such that if you were discharged or convicted in a military tribunal under something that would be considered a felony in the state of California, at that point, they can add you to the list of, hey, this officer needs to be decertified. So really going back in time into your background, you know, something that maybe you thought was dead and gone in your past life of military service. Now you've been working for a police officer for however long. If they determine that that was a problem way back when, that can be something that rears its ugly head, and you're called to fight against. And what's really interesting is that they can put you in a national index, and this national index is essentially the list, right? The list of officers who are essentially ineligible to be police officers, not only in the state of California, but nationally. And the Post Commission is going to look at this list and say, well, if you had committed misconduct elsewhere, would it be something that the state of California also takes a tainted look at and decides that, hey, you know, whatever happened in Montana, it's not going to be good for California. Right. And they'll look at you that way. Another change, and this is something that I deal with regularly, and now I'm going to always have to be cognizant of, is certain protections in terms of privacy rights for police officers have completely been diminished, such that there is not going to be a requirement for pitches on certain sustained findings. So previously, had you had some discipline or misconduct in your file, public defender files a pitches motion, the city goes and defends it, decides whether or not to release it for purposes of use in a criminal case, right? Certain sustained findings are no longer going to require pitches motions. So if you have something in your background, there's not going to be that motion and in camera process where the judge determines, okay, I'll release this, I'm not going to release that. Public defender, you can have this under a protective order. Now it's just kind of fair game. And those specific allegations have to do with unreasonable or excessive force, failing to intervene when another officer is using unreasonable or excessive force, or unlawful arrest, unlawful search and seizure, and anything that has to do with prejudice or discrimination. That's an interesting one too, because I mean, as you know, cops kind of have like to make light of things and joke around to kind of stay sane, right? And so we have instances where if a off-color joke is made, now suddenly, even if you did not mean it in a discriminatory way, if it's objectively, discriminatory, that can be disclosed. And so, and I mean, when we're talking about discrimination, we're talking about like mental disabilities, race, gender, sexuality, all the, the normal ones, ancestry, that kind of stuff. So that's a crazy situation just for a defense attorney perspective for police officers, because things that we thought we could make sure that, the officer's been disciplined, much like regular people in any job. You've gotten in trouble, you served your time, or, you have the write-up in your file and you think it's done. That can come out without as much due process as there has been. And then probably the biggest change and most significant for law enforcement from SB2 would be this commission for post to review and determine if officers should be decertified.
Oh yeah, that's one I want to get on a little bit. Who makes up that commission? Because I think it starts off.
It's pretty crazy. There's only 9 of them, right?
Right. And they're I believe governor appointees.
Yes.
And it's essentially, if you're being investigated, you've been suspended or terminated for certain conduct, they will do a separate evaluation, right? So they won't take your investigation that's already been done by the department or an outside agency. They're going to do their own investigation. They're going to require officers to participate in that or make almost like a default finding. So you
have no choice. You have to participate, whether you were exonerated or not.
Yep. And so those are for dishonesty, abuse of power, the unreasonable or excessive force, sexual assault, obviously, and then demonstrating a bias or prejudice, like we talked about earlier. But also, what is a crazy language that I'm hoping gets adjusted, but we won't know, is acts that violate the law and are sufficiently egregious or repeated as to be inconsistent with an obligation to uphold the law or respect the rights of members of the public as determined by the commission. I don't know what that means to you.
That sounds like a loophole is what it is.
You're the attorney, and yeah.
I mean, I think, anyone who wants to make an argument could, that almost across the board conduct could fall into that category.
So I have a question with the where is it, the bias, right? So they said, okay, any type of discrimination with that, but now officers on any type of self-initiated stops have to fill out like a anonymous, the RIPA, I couldn't think of what it was called. And they're forced to decide what their race is or what their sexual preference is and all of their identity, all those things. And although it's anonymous, but they have a number attached to them, are they going to be pulling that from DOJ and trying to attach that to this thing?
That's a really good question. And I don't know the answer to that. I think, honestly, we don't know the answer to a lot of the questions related to SB2. So this past January 1st of this year, right? I have not received any kind of notification as to any of my clients going through the process yet. But I imagine that it's going to be just kind of fluid and we're going to kind of learn as we go. And it's very possible that something like that becomes part and parcel to this law. I just don't know.
I think you can probably, with your caseload currently, you could probably go down the list and figure out which cases are going to be SB2 cases at face value. But it's one commission for the entire state, and
they're going to be inundated with stuff.
Yeah. So for an officer who might be cleared or exonerated on something that qualifies for SB2 review, it could be like 5 to 10 years and their numbers up. And this commission may dictate the fate of this officer. That's kind of not fair.
And what else is crazy is that actually have an issue at one department and lateral to another and have a great career where you're doing all kinds of awesome things for the community, and this come back. And
Right.
that is scary, right? Because everyone makes mistakes, of course. Police officers are no different. They're put in a situation where they have, to make split-second decisions. And yeah, you could be revisited by something that happened at 1 or 2 departments ago, years ago.
So there is no like end date, like you have to they have to contact you within 30 days of them getting the review or anything like that.
We were very concerned just from our perspective with this particular practice of how back in time they will go. I can see potentially having officer-involved shootings re-reviewed, that kind of thing. I don't know. And honestly, I don't know if some of it will also be driven by civil lawsuits. There's oftentimes that I have cases where the department is working on something and it becomes exacerbated by a civil lawsuit. I mean, I'm sure you know what I'm talking about. Suddenly, someone's much more hurt than they originally were or what have you, because there's dollar signs attached to it.
Yeah.
And I don't know if that will also drive review of some of these cases. If you see that not only is there a departmental review, but a public review in, a court of law civilly. So I don't know.
Yeah.
All I know is we are planning to be very busy.
Yeah.
To the point where I'm pretty sure that we will have an attorney dedicated to this in my office, just based on the number of departments that we represent. And the fact that, someone is going to be the initial case, and someone is going to be the case where they continue to figure out how they're doing this commission and post. So there's going to be the advisory board, right? The advisory board makes the recommendation. The hearing officer, or I'm sorry, you're going to be able to have a hearing, right? It's going to be one of those things where you get a hearing before an administrative law judge. If this adverse recommendation comes from the commission to decertify you, administrative law judges are an example is what the state personnel board uses for the state of California. So unlike some police departments that have a neutral hearing officer who could be a attorney or not an attorney or what have you, an administrative law judge is what the state of California uses on their discipline cases. So when I represent our correctional clients, that's who we go before, an administrative law judge. So then the administrative law judge decides yes on the revocation or not. Then at that point, you can appeal the administrative law judge's ruling to the Superior Court, which again is always hard because we have clients who have personnel matters, right? And those typically are protected and closed files. And then once you go to Superior Court, it's public record. So, I will have clients who have to make decisions on how far do I want to take this? How much do I want the public to know about, allegations made against me, true or false, but how much do I want the public to know? Because you and I know newspaper headlines don't care, reporters don't care.
Right.
Here's the headline, and then they move on, and you're dealing with the aftermath, right?
Yeah. Wow. It's a lot. It's a lot.
Yeah. So for someone like me, I worked in a custody environment. I was a deputy sheriff for 5 years, and I worked in men's central jail for 5 years, and I used a lot of force. It's part of the job. All that is that something I have to worry about now? Could that conceivably be brought up, even though I was exonerated from any accusations that may have arisen from that? Could that come up in SB2?
Yes, because what the bottom line is, this group is saying, we understand that your department did an investigation. That's great. We don't even want to use it. We're going to do our own. You are going to come for a new interview. We are going to re-review witness statements and see if we need to interview them ourselves. So you may have been exonerated. This group may now say, not in our eyes.
Right. You know what's scary
Yeah.
about that is you think of when you're being judged, typically in a court, you're judged by a jury of your peers, right? And even in a traditional court, and you're a police officer, to me, a jury of your peers would be a jury of police officers, right? But this advisory board or this review board, I heard some interesting things. I heard that only 2 of them would be retired police officers out of the 9. 2 of them were people that had family members that were victims of police brutality. And then the other ones were, I forget where they're from, but the rest of the group, the other 5 are made by people that just have a skewed view of police in general. I mean, I think we're starting at a disadvantage to begin with, aren't we?
It's not good.
No.
It's not good
Yeah.
because, I agree with you, a jury of your peers and whether or not an officer used force reasonably, it's an objective standard, right?
Right.
But you still use the standard of the reasonable officer on the scene for that review. And none of these people, unless they are those retirees, are going to be able to put themselves in a position where they're able to make that determination, right? Because you know that there's different tactics that you can use, right? But I routinely hear from people about, well, why didn't the officer shoot him in the leg? Or, why did he have to use that kind of force? Or, I've had some pretty gnarly officer involved shootings recently where, officers use quite a bit of their magazine. And, a normal person who doesn't understand that you have to stop the threat until the threat is done. Well, why did you need more than 1 or 2 bullets? That kind of thing.
Yeah.
So it does concern me, obviously, because I don't know how these cases are going to be selected. I don't know whether or not departments who feel like maybe they didn't have a very strong administrative case for a termination may say, that's fine, we'll just send this over to the advisory board. I don't know. And I feel like it will be one of those things where, at least amongst my peers, the LDF panel attorneys, we're probably going to have continuing education on this. Hey, what happened, on your case, what happened in Northern California? Here's what we're doing down here in Riverside and San Bernardino counties, kind of like what we're having to do on the 1506 shootings, right? My law firm was one of the first ones to have one. And going through that process, I received so many phone calls from other attorneys saying, okay, well, so what did DOJ do and how did they do it? And is this how they're going to do it? And what did you do? And, so this is going to be one of those things where we're going to have to learn how to defend the police officers on misconduct, not only administratively, maybe criminally, definitely civilly, and now with this other component.
Right.
It's great. And I'm hiring more attorneys who like the police only.
Yeah, I mean, it
Send them
does
my
take
way.
a special. It does take a special attorney. I mean, we talked about it pre-show. You can't just be an attorney that wants to work for your particular firm. You have to be someone that actually it doesn't have any bias towards law enforcement, right?
Right.
So it does take a special. If you're out there and you want to join this world, they can find you. Is your firm on Instagram?
Yes, we're on Instagram, we're on Facebook, we're on LinkedIn. We have a webpage. We have 3 offices in Southern California. If you come and work for me as a legal defense attorney, you'll be driving because you drive to the police departments, you drive out when there's shootings. We try and do stuff like this remotely. More and more now that COVID is over,
Right.
we are back to driving. So it takes a special kind of person to understand that you may be kind of a truck driver with a law license. I drive all over the state. I don't mind it. And I feel like the work that I do is very important. When I was a DA, I used to sentence people to prison and go out to lunch and not think about them again. I have a lot more anxiety in this job because these people are my friends. They're my family, could be my husband that's going through this. And so it takes a special kind of person who wants to defend the police. but I will tell you, I have the most job satisfaction ever, and I'm very proud of the work I do. So
Yeah, that's
this
awesome.
is my plug for anyone out there. who wants a
Yeah, no,
job,
seriously.
because I'm
Heck yeah.
hiring.
No, if I was an attorney, I'd definitely work with you. You're a fun person. And yeah, Castillo and Harper, look up Castillo Harper, go ahead and Google it, and you should reach out to them. Kasey's a very friendly person. So is Brandy. And as a matter of fact, you were so accommodating, you moved an interview for one of your potential hires to make this happen. So thank you for doing that. So
Of course.
it shows that you're
Yeah,
flexible
thank
as
you.
well.
Yeah.
So before we wrap up here, there's no question that SB2 is very confusing. I don't even think it takes an effect officially till later, right?
I think the wheels are in motion to
Yeah.
figure out how to do this. And I'm pretty sure that, well, I mean, it was in effect as of January 1.
Okay.
How it starts working is another thing. And what we're seeing, it's like we've seen with 1506, right? It took place, it went into law, and then the state had to figure out, okay, now we have to have DOJ investigators. So they're pulling from lottery and fish and game and whatever else, what other agencies they have. And then they're creating teams, and then they're sending those people to school for investigations. Yeah. So I think it's going to be something like that where, okay, now we have it in law, and now we have to figure out how to implement it. So I actually have no idea when we're going to start seeing or getting notified that our clients are under review, or to start participating in these investigations, because there is going to be a whole investigation process before we even come close to any kind of a hearing.
Well, I'm sure your firm will probably be amongst the first to work with that, because you have your hands in so many agencies throughout California. So we'd love to have you back one day after you've experienced something like that. Because
SB2 update
Or no more. Yeah.
No problem.
Well, we're certainly glad that there's attorneys like you that have our back. I think a lot of people don't realize that police need a support group to help them with their administrative legal needs. And you guys are there. You guys answer your phones 24/7. I personally know people that have used you as their representative. So I'm so glad people like you exist, because this would be a scary job if we didn't have attorneys like you that cared
I appreciate that.
to represent us. So, well, thanks for taking the time to join us. I know we just barely scratched the surface on what SB2 is, and we would need a series to really just cover this. But we'd love to have you back one day if you're willing.
Absolutely. And I'm definitely volunteering Brandy on social media training if you want her, because that's
great,
one of her favorite topics.
Yeah. I think we're definitely gonna have to bring her on after she critiques my page for a little bit of what not to do.
Yeah, we'll need it.
A case study, what not to do.
Yes, exactly. All right. Well, thanks for joining us, Kasey. And thank you guys for listening to this episode of the 91 Strong podcast. We know you have your choice to listen to us to anybody, but we thank you for inviting us into your homes, your offices, and on your drive. And we hope you learned a little bit about some of the things officers have to think about and not think about, and some of the consequences that happens when we don't think. So we appreciate those reviews and comments. If you liked this episode, drop us a line and we might read it on the next episode. Thanks for joining us, and we'll catch you on the next episode of the 91 Strong podcast. See ya.
Bye.